Good morning, everyone, and welcome to our next in the series of webinars. This one is on redundancy and furlough. I hope you'll find the webinar useful and will join us in any future webinars. I'm going to turn the video off so we can concentrate on what's on the screen. Thank you for joining us. So first I'd like to introduce myself, Lynn Berman. I'm the HR business partner at Clover HR, and day to day I support a number of employers on a range of topics, from ad hoc issues of short-term, long-term absences, disciplinaries, policies and contract reviews. I've been involved with various small and medium-scale redundancies and a crossover of roles and responsibilities. I've also been involved in restructures and downsizing. So that's just a little bit about me. This is the team at Clover HR. We have expanded rapidly over the last 6 to 12 months. So this isn't the complete team, but we are your trusted people advisors. We've all got specialisms in different areas, from recruitment, learning and development, coaching, health and safety. And we're able to provide valuable support for your employer in all areas. This picture was taken back in March. However, we are hoping to get together after lockdown and have a more recent photo. So at the end of the webinar, I will be providing my contact details again for you to look through, but if there is any questions or queries, please don't hesitate to email me direct or ask on the chat option and I can get back to you later. Hopefully all microphones have been muted, and I ask that you keep your microphones muted just so we can concentrate on the screen and on the information, and any background noise is kept to a minimum. Okay, so what will I be covering today? Quite a wide variety of information to give to you today. So we'll be looking through redundancy and the job retention scheme, managing redundancy, planning redundancy, the selection pools and volunteers that you have to look at, consultation process, the dismissals part, redundancy costs and payments, and the new job support scheme that's coming into play on the 1st of November. Okay, so first of all, what is redundancy? Before we get into that, what is defined as redundancy situation? And redundancy is a special form of dismissal which happens when an employer needs to reduce the size of its workforce. So in the UK, an employer is dismissed for redundancy if the employer has ceased or intends to cease continuing the business, or the requirements for employees to perform work of a specific type or to conduct it in a location in which they're employed has ceased or diminished or is expected to do so. So if there's a genuine redundancy, employers must follow the correct procedure in line with UK employment law. Employees who don't may be liable for unfair dismissal or protective awards. Redundancy can be very challenging and an upsetting situation for affected employees and also the wider workforce. So announcing redundancies can affect employee morale, motivation, productivity. And it's vital for employers to handle redundancy situations with sensitivity and in order to reduce the negative impact it may have. So the furlough scheme, before I get into the process of redundancy, I want to cover off how the redundancies are being affected by the coronavirus job retention scheme that was put in place this year, obviously during lockdown, and the additional considerations that has been in place for businesses. So the job retention scheme was implemented to avoid redundancies as a result of the current pandemic. The original scope of the scheme you'll see on the screen was to save jobs and protect the UK economy during the pandemic. The overriding purpose of the scheme obviously was to save jobs, but the guidance seems to indicate that employees may be made redundant while on furlough or afterwards. The note for employees states your employer can still make you redundant while you're on furlough or afterwards. And the note for employers states that the government ends the scheme, once the government ends the scheme, they must make a decision, depending on the circumstances, as to whether employees can return to their duties and if it's necessary to consider termination of employment or whether you can save their job. So the guidance is quite clear. Whilst on furlough and afterwards, employers still have the same rights in relation to redundancy rights and protection from discrimination or unfair dismissal. Therefore, it's crucial that employers only implement redundancy dismissals where there's a genuine redundancy situation and when they've followed a fair redundancy process in line with UK employment law. So that said, the availability of the coronavirus job retention scheme and other government support packages available does add another layer to the normal redundancy process we have. So employers must also show they have tried to avoid redundancies, proceeding without considering current government measures in relation to coronavirus measures as alternatives, such as placing employees on furlough, and that may encourage employees with over 2 years service to present unfair dismissal claims. The usual redundancy processes must be followed, as I've stated earlier. This means following the company's own procedure, if there is one in place, and the stages defined by UK employment law. Employers who have already furloughed employees can still start the redundancy process once all the alternatives have been exhausted. Of course, the furlough scheme ends at the end of October, so there are only 4 more weeks remaining of this. So below, I've outlined the main considerations for businesses in regards to the redundancy whilst employees are on furlough. So firstly, the logistical issues. How will you communicate with your infected employees? Can the consultation process be conducted remotely? Do all the affected employees have the equipment and skills to participate in a digital process? So I've been involved in some redundancies where they may be virtual, on Zoom, on Teams. You have to check with the employee about this. This has to be a 2-way process. Then how is the business proposing to select employees for redundancy? Is this based purely on the fact that they are furloughed? If so, there is a risk, depending on the reasons for employees who have been placed on furlough in the first place and the selection process that was used to do this, that the approach may be given rise to claims of discrimination and unfair dismissal. Where an employer could have retained an employee on furlough, a redundancy dismissal may be deemed unfair if you're not sure of how it will pan out in the next 4 weeks. Also, employees may be entitled to be paid their full salary during their notice period. So even if you're paying 80% during furlough, if they're working their notice period or not working their notice period and on furlough, they need to be paid at full salary. So it's important to remember that new government guidance is being published regularly during the pandemic, and therefore it's important for both us and businesses to keep matters under close review, which we can help you with. So managing redundancy. Now we're moving on to the redundancy process itself. So once you've decided there is going to potentially be a redundancy situation, the exact procedures will vary according to the timescale and size of a redundancy programme, but the below stages are recommended as a minimum. So the planning stage, identifying the pool for selection, seeking volunteers in this process, and I'll go on to that later, consulting employees, selection for redundancy, appeals and dismissals, suitable alternative employment, redundancy payments and counselling support, both for the employee being made redundant and the other employees in the workforce. So every employer should consider having a formal redundancy procedure. So throughout the planning phase, businesses should always attempt to avoid redundancies, as we've said, where possible. So some of the suggestions to avoid alternative approaches, to consider, could be natural wastage. When people leave, you don't replace. Recruitment freezes, stopping or reducing overtime, offering early retirement to volunteers. Here you need to ensure that compliance with age discrimination laws is in place. Retraining or redeployment of employees elsewhere in the business, offering existing employees sabbaticals and secondments, pay freezes, short time working, reducing hours, and any other alternatives to redundancies by where employees do not work for their employer during a specified period and are free to seek new work whilst receiving an allowance. This could be an option. But it is important to note here, before being able to implement any of the above changes, you need to check employees' contracts to enable you to do so. So the planning phase. On another note of planning, you need to be mindful that where redundancy will involve 20 or more employees, you must inform the redundancy payment service before the start of the consultation period begins. So identifying the selection pool. You must carefully identify the group or groups from which employees will be selected for redundancy if more than one person is in that role. This will usually consist of at least one of the following. So those who undertake a similar type of work, those who work in a particular department, those who work at a relevant location, or those whose work has ceased or has been reduced or is expected to do so. In many redundancy situations, the employer may identify a range of selection pools. If the employer fails to consult and consider a selection pool correctly, dismissals will be legally unfair. So seeking volunteers. As an option, you can consider offering voluntary redundancy as an alternative to compulsory. So this gives the affected employees an option to volunteer to take redundancy when the business is faced in a redundancy situation. An incentive is normally offered in exchange for the employee volunteering. And there are pros and cons to offering voluntary redundancy. So on a positive note, offering voluntary redundancy is viewed as a more positive move from an employer than simply enforcing redundancy onto employees. However, on the other hand, you can risk losing your best employees, as it's often the people who will offer themselves up as they are confident in finding new employment elsewhere. However, it's not mandatory that you actually select anyone who offers themselves up for redundancy, so you can consider this at that point in time. Also, another point to bear in mind is that costs can be higher, as the employees with most to gain financially are often the ones that choose to go. So consulting with affected employees. There are a few things to point out as part of the consultation process. Firstly, as well as individual consultations, if 20 or more employees at one establishment are to be made redundant, collective consultations with recognised trade unions or elected representatives must start with minimum timescales. So if a dismissal of 100 employees or more, it's at least 45 days notice for notification of redundancies, and if it's dismissals of 20 to 99, it's at least 30 days before the notification. So collective consultation must be completed before notices of dismissals are issued. If there are no recognised trade unions or employee representatives, the employer must facilitate an election by the employees of representatives for the consultation. The law requires a meaningful consultation, so it's not enough to inform the employees of the decision that has already been made. Bring them in and get them involved in this. If you are looking at making less than 20 employees redundant, then there is no minimum time scale for this. However, the individual consultation process again must be meaningful and may also be covered by contractual terms and policies. It's also important to note that employees are entitled to be accompanied at all individual consultation meetings by a trade union representative or colleague. So please offer this up at the first instance. So what do I mean by a meaningful consultation process? A meaningful redundancy consultation process means more than simply informing the employee of the decision already made. So ACAS state that you should listen to the employee and genuinely consider any of their suggestions. This will give you a better chance of finding alternative jobs for affected employees and provide an opportunity really for ideas and options to surface that you hadn't considered, because at the end of the day, they're the one doing the job. There needs to be a two-way dialogue with the objective of finding ways to avoid dismissal if at all possible. For example, job sharing, sabbaticals, reduction of hours. You're not quite sure how the employee is feeling until they're in that situation. At the start of the consultation process, the employer is legally obliged to give the following information. So the reason for the redundancy dismissal potentially, the number of proposed redundancies and their jobs, the total number of affected employees, the proposed method of selection, the procedure to be followed in dealing with redundancies, and the method of calculating the redundancy payment. Some companies do statutory, others may introduce enhanced redundancy. So it's important to note that at this stage. So in selecting employees' redundancy, choices must be made based on objective criteria. So we need to look at potentially length of service, only as one of the number of criteria. This can't be the only one. Attendance records, disciplinary records, skills, competencies and qualifications, work experience, and within the variety of jobs that they know, and performance records. And remember, objective selection criteria can be weighted depending on what you need for that potential job. Last in, first out is a risky selection method, as those with less service are likely to be younger, so it could result in potential age discrimination. That said, Case law does show that last in, first out may still be relevant as part of a wider selection criteria, but it must not be used as the sole method, and you must be able to justify using this. An employment tribunal looks favourably at selection procedures based on a point scoring system, which scores each employee based on the relevant criteria. So it's important here that you take care in the choice of application and selection in order to avoid any discrimination claims in the future. Scoring should, if possible, be carried out independently by at least 2 managers who know all employees in the selection pool. So the marks from the 2 assessors should then be added together to give a total score for each employee. So just going back to the employees on furlough and selection process for you. Automatically select employees for redundancy on the basis that they have been furloughed could be problematic for a number of reasons. Firstly, looking at how the employees were selected for furlough to begin with, what was the process and criteria used, and whether these were fair in the circumstances and remain fair. It's likely that at the point redundancy becomes necessary, an employer would have to reassess the fairness of pools and the selection criteria and consult employees to ensure that the redundancies are not deemed unfair. So secondly, you need to review if the employees are on furlough was due to caring responsibilities or shielding or for health reasons. Selecting these employees for redundancy is likely to constitute indirect discrimination based on sex, disability or age. And finally, there remains a grey area around the question of whether selecting someone for redundancy when they could remain on furlough may result in unfair dismissal. Employees need to consider whether it would be reasonable in the circumstances to wait until the furlough scheme ends and the company is no longer to claim employee costs under the scheme before implementing any redundancies. And as I said earlier, the furlough scheme does end at the end of October, so we have 4 weeks really to decide. So moving on to dismissals and appeals. The employee should give written notice to those selected for redundancy that they are at risk of redundancy and invite them to individual consultation meetings. At least 1 further consultation meeting should be held. The actual number of meetings will depend on what the employee has to say. So the employee must consider all points that the employee puts forward and give answers based on whatever they suggest. Once the individual consultation is complete, the employer must decide whether the employee is to be made redundant and give a redundancy notice, a written redundancy notice. This will be the statutory minimum notice or the contractual notice, whichever is the greater. The employee must also explain the redundancy payment calculations to the employee, how it will be paid, when it will be paid. And remember, all employees should be allowed to appeal against the redundancy decision. One other alternative is to look at suitable alternatives. So I've got some points I wanted to cover off here. Employees must also consider offering suitable alternative work to employees being made redundant, so if there is any other roles within the business. If employees unreasonably refuse that suitable alternative work, they may lose their entitlement to a statutory redundancy payment. However, employees can have a 4-week trial in a new role, and if the employer and the employee then agree that the role is not suitable, the employee reverts to being made redundant again. So the law requires employees who have at least 2 years service to be given paid time off to look for work during the final notice period as well. So this helps them obviously set themselves up for the future. So when we're looking at redundancy costs, there are various direct and indirect costs to employers associated with redundancy. So contractual or statutory redundancy payments. Employees with 2 or more years service are entitled to a minimum statutory redundancy payment, which currently explains their half a week's pay for each full year, and it goes up based on age and length of service. The weekly pay is capped at 538 at this stage, and that is the maximum statutory redundancy pay. It's 16,140. The indirect costs include management time, obviously for the consultation meetings, letters, high labour turnover. This could constitute more people leaving due to being at risk, and obviously lost output resulting from reduced morale potentially, and engagement of survivor employees. What do I mean by survivor employees? So survivor support. In any redundancy situation, the employer's immediate obviously priority should be the fair and sensitive treatment of those employees who are losing their jobs. So once this has been achieved, the business's ongoing effectiveness is largely dependent on the morale of the survivors, the rest of the workforce. Fair to say, a demoralised workforce who are anxious about their job security and critical of how the business has handled the redundancy process is not likely to feel committed or engaged. So to help support those who continue to be employed through the process, it's a good practice for the businesses to give a full explanation to those employees who remain, including the redundancy procedure that's been used, explain the need for the changes, given an overview of further reorganisational changes or work arrangements in the future, just to secure them, provide a forward-looking positive attitude for the future and show the survivors the value of their role and how they impact on that future business, and carry out individual discussions with remaining key workers where necessary, just to reassure them of their importance and employment prospects. This will certainly help employee morale and gain their input and engagement straight away. So, with effect from the 1st of November, recently the government are introducing a scheme called the Job Support Scheme. Employees will get a minimum of 77% of wages under the minimum rules of the grant if the government cap is not reached. So this has been planned to run for the next 6 months and will end potentially at the moment at the end of April 2021. Employees and employers do not previously have had to be part of the job retention scheme, and there'll be no test for SMEs, only large businesses at this stage. So to qualify, the employee needs to have been processed through payroll before the 23rd of September 2020. For each hour worked, the employer will pay a third of the employee's contractual normal wage, and the government will also pay 1/3, leaving 1/3 unpaid. The government's 1/3 will also be capped at £697.92 per month. So if the employee chooses to top up to full pay, they can do this. In the first 3 months, the employees will work at least 33% of their normal hours, and the government will revise this at a later date, so constantly keep checking and we will advise you of any changes in the future. Employees have to pay 100% of the wages for the time that the employee is working. The grant does not cover national insurance or pension contributions, however. One important thing to note is the employees cannot be put on notice while claiming on the scheme, significantly different to the coronavirus job retention scheme. So the employees will need to give consent again to join this scheme, as it involves a deduction of wages and change of terms. So in summary, key stages to managing redundancy are the planning stage, identifying the pool for selection, seeking volunteers, consulting employees, selection for redundancy, appeals and dismissals, suitable alternative employment, redundancy payment and counselling support. You can start the redundancy process while the employee is on furlough. However, you need to demonstrate that you've exhausted all other options, and continuing on furlough cannot alter the course of events. So just a final note from me. Redundancy should be a last resort. It can be one of the most distressing events an employee can experience. As a result, it requires sensitive handling by the employer to ensure fair treatment of redundancy employees, as well as the productivity and morale of the remaining workforce. Documentation throughout the process is vital to be able to demonstrate fair process, and any court of law looking at it in the future, if the employee was to dispute this, would look at all documentation. Making someone redundant because of their age, sex, sexual orientation, marital status, disability, race or religion, or any other protected characteristic is unlawful under the Equality Act 2010. So every redundancy situation process will be unique. Just as a general point, I want to emphasise how whilst the subject is still relevant and we have another month of furlough and redundancy, a lot of these decisions have already been made. So the importance of redundancy and ensuring that the key areas of the process of redundancy are understood are crucial at this stage. So thank you for listening. I hope you've enjoyed, or it's been an informative webinar for you and has gained a lot of your attention. We've covered a lot of topic, but I hope you found it useful. Here you'll see the attached links to our upcoming webinars. So we have a series going over the next couple of months. You'll find the information useful. It's on a variety of topics. And if you want to have a look at the Clover HR website as well, you can certainly view this and see this video or other webinars on the link and on YouTube. So that's my contact details. If you do want to contact me after today or contact Clover, feel free to, and we can help you. Obviously, the subject is very sensitive. So if you do want to contact us privately after this for any advice or anything like that, or a copy of the webinar to show your employees or colleagues, then please let me know. Thanks again for listening. I hope you found it useful, and don't hesitate to call me for help. Thank you.